Employee and labor relations, common law doctrine, employment at will. At will means that an employer can terminate an employee at any time for any reason except an illegal one, or for no reason without incurring legal liability. Likewise, an employee is free to leave a job at any time for any reason or no reason with no adverse legal consequences. Employment relationships are presumed to be at will in all U.S. states except Montana. The U.S. is one of a handful of countries where employment is primarily at will. Most countries throughout the world allow employers to dismiss employees only for cause. At-will employment also means that an employer can change the employment relationship without notice and with no consequences. For example, an employer can modify wages, terminate benefits, or reduce paid time off. The law typically presumes that you are employed at will, unless you can prove otherwise, usually through written documents relating to your employment or oral statements your employer has made. A contract can modify the presumption of at-will employment. For example, a contract may provide a specific term of employment or allow termination for cause only. Usually, U.S. companies negotiate individual employment agreements with high-level employees only. A collective bargaining agreement, CBA, is a written legal contract between an employer and a union representing employees. Employees under collective bargaining agreements are typically only terminated for cause. The CBA, collective bargaining agreement, results from an extensive negotiation process between the parties regarding topics such as wages, hours, and terms and conditions of employment. Cause includes reasons like poor employee performance, employee misconduct, or economic necessity. An employment contract may specifically outline the situations or employee actions that would lead to termination for cause. Over the years, courts have carved out exceptions to the at-will presumption to mitigate its sometimes harsh consequences. The three major common law exceptions are public policy, implied contract, and implied covenant of good faith. Under public policy exception to employment at will, an employee is wrongfully discharged when the termination is against an explicit, well-established public policy of the state. The public policy exception is the most widely accepted exception recognized in 43 of the 50 states. Generally, the public policy exception has been applied in 4 areas: employees who refuse to break the law for their employer, employees who report illegal acts of their employer, whistleblowers, employees who participate in activities supported by public policy, such as cooperating in government investigations of wrongdoing by the employer, and employees who are acting in accordance with legal statute, such as attending jury duty and reporting workers' comp claims. An implied contract is a contract that exists based on the actions of those involved. Though it is not a written or spoken contract, it is just as legal. A contract is assumed to exist based on the behaviors of the parties to it. An implied contract can be created by an employer's conduct and need not be specifically stated. For example, an employer's consistent application of a progressive discipline policy can create an implied contract that an employee won't be terminated without first going through the steps set forth by the policy. A disclaimer can offset the effects of an implied contract. However, there is little agreement in the courts as to what and how the disclaimer must be presented in order to maintain at-will status. For example, To avoid establishing unintentional contracts with employees, employers may want to include in their handbook a clear and conspicuous disclaimer that the handbook is not a contract and merely contains guidelines or policies. Implied covenant of good faith and fair dealing is a tenet of common law that provides that parties to a contract have an obligation to act in a fair and honest manner to ensure that contract's benefits may be realized. The application of this doctrine to at-will employment issues varies widely from state to state. To be clear, the at-will presumption is strong. It can be difficult for an employee to prove that circumstances fall within one of the exceptions of public policy, implied contract, or implied covenant of good faith. Further, all exceptions are not recognized in all jurisdictions. For the SPHR, employee relations and engagement makes up 20% of the exam content. You must be able to develop and/or monitor strategies impacting employee satisfaction and performance, including diversity and inclusion, safety, security, and labor strategies. I'm wishing you good luck. However, if you study hard, you won't need it. Join the 365 HR Certified Study Group on Facebook today. It's free. Information compiled from PHR SPHR Study Guide by Sandra M. Reed and Ann M. Burgaitis and the World Wide Web. If you are studying for the PHR SPHR, you should purchase this book as a comprehensive study tool, which I believe you will find invaluable as you seek your HR certification.